Welcome to day 7 of our 8-day estate planning action plan. I'm John Farrell with the Farrell Law Firm. We're almost at the finish line, and today we're covering one of the most well-known estate planning documents, the last will and testament. You might think of a will as something only the wealthy need, but the truth is everyone should have one. Your will ensures that your loved ones are taken care of and that your assets go exactly where you want them to. Let's break it down. A last will and testament is a legal document that outlines, number 1, who gets your assets after you pass away. Number 2, who will manage your estate? This person is called your executor. And number 3, who will take care of your minor children if applicable? Without a will, Georgia law decides for you. That means the court will distribute your assets based on state rules, which may not reflect your wishes. It can also lead to family disputes and unnecessary delays. If you don't have a will in place, Georgia law follows a process called intestate probate. This means the state has a predetermined order for who inherits your assets, starting with your closest relatives. That might sound fine, but here's the catch. If you're married, your spouse might not inherit everything, especially if you have children. If you have minor children, a court will decide who raises them, not you. If you're unmarried, your assets could end up going to distant relatives you've never met, instead of close friends or charities you care about. A will lets you stay in control. So who would be your executor? Your executor is the person responsible for handling your estate after you pass away. This includes paying your final debts, filing necessary tax returns, and distributing your assets according to your will. You should pick someone responsible, organized, and trustworthy. It could be a family member, a friend, or even a professional executor like an attorney or financial advisor. Just make sure they understand the responsibility involved. Now, a will is a powerful document, but it doesn't cover everything. Here's what a will can do. Distribute assets like real estate, bank accounts, and personal belongings. Name guardians for your minor children. Appoint an executor to manage your estate. But here's what a will can't do. It can't control assets that already have a beneficiary, like life insurance or retirement accounts. And it can avoid probate, the legal process for validating a will and settling your estate. That's why estate planning often includes other tools, like trusts and beneficiary designations, to keep things simple for your loved ones. Let's talk about when you should update your will. Even if you already have a will, you need to update it whenever you experience a major life change, such as getting married or divorced, having children or grandchildren, buying or selling real estate, starting or selling a business, losing a loved one who is named in your will. Your will should always reflect your current wishes, not what you would have wanted 5 or 10 years ago. So here's your action item for today. If you don't have a will, now's the time to create one. And if you do have one, take a few minutes to review it. Does it reflect your current wishes? Is your chosen executor still the best choice? Have you had any major life changes that require an update? If you need help drafting or updating your will, we're here to guide you through the process. Thanks for joining me for day 7 of your estate planning action plan. Tomorrow is our final day, and we're going to wrap everything up. Make sure you subscribe to the channel because we put out new videos almost every day, and make sure you hit the like button. I'll see you soon.